Hello everyone, I'm Anneliese. I'm going to be talking to you today on mortgage stress. I'm the Toowoomba-based lawyer in our Consumer Protection Unit, so one of the new lawyers just employed, so I'm very happy to be working with Paul and Loretta and Catherine and the rest of the CPU. So there's a fair bit to cover today, so I think we'll get into it. There's a whole range of different problems that people can run into with their loans and their mortgages. So, for example, unjustness or irresponsible lending issues. That might be if they shouldn't have been given the loan in the first place, if the loan was unsuitable for their purpose, or in some circumstances if they wouldn't have been able to afford servicing the loan over the course of the term. People can run into hardship quite frequently. That might be short-term or long-term. It might be due to unemployment or illness or any number of reasons. They can fall into default and receive default notice. They can be on the receiving end of court proceedings instituted by the bank or the financier. They can even reach the stage where they're being evicted from their home. There could be issues with refinancing or different types of loans, for example, bridging loans or reverse mortgages. They could run into issues with mortgage brokers, for example, misrepresentation issues and that type of thing. Mortgage insurance, and a fairly common one can be family breakdown and debts. So what will we cover today? There's a fair bit, so I'll skate over this pretty quickly. We can take questions at the end, and you can always contact us for more information if you need it. We will look at the legal framework for regulated loans, financial hardship, internal dispute resolution and external dispute resolution, and the repossession process and the mortgagee sales. So this is the real basic stuff. Of course, there's a difference between a loan and a mortgage. The loan's the agreement under which the money is lent out. The mortgage is the security, so that's an encumbrance on the person's property. And usually the mortgage will set out the terms of enforcement, so under what circumstances the lender can repossess the home if there's a default. Now, the legal framework, I've put that picture up because it can be quite scary and make you want to scream. There's the National Consumer Credit Protection Act. As part of that, in the schedule to that act, there's the National Credit Code, and there's also the Banking Code of Practice, which is a voluntary industry code of practice. So the Act is the overarching piece of legislation, and it governs consumer loans and mortgages, but all the detail is usually in the Credit Code. That's in Schedule 1 of the Act, and that applies to loans where the debtor is a natural person, so an individual or sometimes a strata corporation, where the credit is provided mostly, and by mostly we mean over 50%, for personal, domestic or household purposes, or to purchase, renovate or improve residential property for investment purposes, or to refinance credit that's being provided for residential property investment purposes. The other two things usually, a charge is made for providing the credit, and the credit provider is in the course of business of providing the credit, so a bank, financier, that type of thing. So, for example, the code won't apply to business or investment loans unless the investment is in relation to residential property. It won't apply to loans to companies. It won't apply to loans between friends and family because they won't usually be in the business of providing loans or credit. Now, it applies to mortgages where the loan is regulated and the mortgagor is a natural person or a strata corporation. And if sometimes you get the situation where a mortgage can secure obligations under a code-regulated loan or a non-code-regulated loan, and to the extent that it secures obligations under the regulated loan, then it will also be regulated by the credit code. So, look, the credit code's pretty complicated. There's a whole range of regulations in it which have an impact on the loans, so they must be in writing and signed. There's certain pre-contractual disclosure information that the consumers must be given. Consumers generally have a right to request a hardship variation. The banks and financiers have certain responsible lending obligations, and there's also a process for enforcement and when the loan falls into default. Similarly, for a mortgage that's code regulated, there's certain formal requirements. The property has to be able to be described or identified, so you can't have a mortgage over all property owned by the debtor, for example. Now, moving on to the Banking Code of Practice, this is a voluntary code of conduct for the banks. I understand that most, if not the vast majority of them, certainly subscribe to the code. There's been a change, there's been a new code that came into effect in February this year. If the bank does subscribe to the code, then it can form part of the contract between the bank and the customer. And there are certain provisions in the code which recognise customers with special needs and customers in remote Indigenous communities. And that's about providing access to services and also providing information, particularly with customers in remote Indigenous communities, assisting with identification requirements and that type of thing. The code also incorporates hardship provisions and the external dispute resolution schemes, which we'll get to a bit later on, will look at the banking code as an example of what is good industry practice. Okay, so moving on to responsible lending. This is under the Act. The credit provider is obliged to make an assessment about whether the loan will be unsuitable for the consumer before entering into the loan or increasing the credit limit under the loan. So that means that they have to make reasonable inquiries about the consumer's objectives and requirements for the loan. So what do they want the money for? What's their purpose in taking out the loan? They need to look at the consumer's financial situation. They also need to take reasonable steps to verify the financial situation. So that can be requesting copies of bank statements, analysing the bank statements, really delving into a bit of detail about whether or not the consumer is in a position to be able to service the loan that's proposed. A credit provider has to assess the loan as unsuitable if it's unlikely the consumer will be able to comply with the loan obligations, or if they could only comply with substantial hardship if they enter into the loan. So if it looks reasonably likely that the consumer won't be able to afford to service the loan on an ongoing basis or over the course of the term of the loan, then it's most likely going to have to be assessed as unsuitable. If the loan's not going to meet the consumer's requirements or objectives, then that will probably be unsuitable. And there's a presumption under the Act that if the consumer could only comply with their obligations by selling their principal place of residence, then that's going to be substantial hardship. Moving on to hardship. This can be quite a common thing. If a debtor has trouble meeting the loan repayments, they can give the lender a hardship notice. Now, under the most recent changes to the credit code, this hardship notice can be made orally or in writing. There's no particular form or no particular magic words that need to be used, but they can ring up the lender and say, I'm in a bit of strife, I don't think I'll be able to meet my payments this week or for this period of time, and that can constitute a hardship notice. The lender can request further information, and that can be information about why the debtor's fallen into hardship, to what extent they've fallen into hardship, what the cause of it is, and what might be a good way to vary the contract so that the debtor will be able to meet certain repayment obligations. The lender can then notify the debtor of the outcome within a certain time frame. I won't go into that because it can be a little bit complicated depending on whether certain things happen. But the important point to remember is that they don't have to agree, but they have to really look at it. So if they're just saying, oh no, I'm not going to even look at giving you hardship, we don't believe that you'll ever be able to service the loan, and they don't really look into the detail of it, then that's not good enough. Generally, I find from experience that banks can be pretty reasonable if they're approached in a hardship situation, especially if the lender has a plan, some sort of idea in their mind, and they don't have to, but it's helpful, practically speaking, if they can go to the bank and say, well, this is what I think I will be able to comply with. And the bank's more likely to assist in a reasonable and timely way if you can have a plan. So there's no limit to what the possible variations could be. The debtor could ask for an interest moratorium for a certain period, or that the bank waive interest for a certain period. They could reduce repayments and extend the term of the loan at the end. They could ask for time to sell the secured assets, so usually the house. They could say, well, I need 3 months to put it on the market and I can make X amount of repayments in the meantime. Often we find that the client can find it useful to work with a financial counsellor to delve into their budgeting details and determine what type of variation might suit their needs. And the application, this is quite an important point, it should show how the debtor is going to get back on track with the loan, because the banks won't agree to a hardship variation if there is no hope that the debtor will ever get back on track. Having said that, in those circumstances, it might be that the only way forward is to look at selling the property, and you can ask for time to do that and that type of thing. But really, you need to show how the debt is going to get back on track. So what if it's refused? The bank should give reasons, and then you take it to EDR, External Dispute Resolution. Most lenders belong to either the Financial Ombudsman Service or the Credit Ombudsman Service schemes, and they are really good external dispute resolution schemes which can look at the hardship request and make a decision on whether or not the bank gave genuine consideration to it, whether or not the loan contract should be varied, and they can actually vary the terms of the loan. Once the debtor can also go to court, but again, the court process is generally, for our types of clients, might be a last resort. There's usually costs involved. It can be risky, and if the client is not successful, then cost orders can be made against them at the end. So generally speaking, EDR would be the way to go, and look at the court process as a last resort. So, IDR and EDR. First, the first port of call is IDR. So you have to go to the bank first and say what the issue is before you go to EDR. Generally, if you don't, the EDR scheme will still accept a complaint, but it will give the parties time to negotiate and resolve the complaint between themselves to start with. EDR is, as I said, the next port of call. So if you can't reach an agreement with the bank, then lodge a complaint with an EDR scheme. So this is great. There's lots of advantages to this because the scheme is free for consumers, not necessarily for the banks. It also puts any enforcement action on hold while the complaint is being considered by an EDR scheme. So that means that whilst the complaint's before the Ombudsman, the bank can't take any action towards repossessing the home and that type of thing. So it puts a stay on enforcement, which can be really useful in the circumstances. EDR schemes are accessible, generally speaking, for consumers who don't have legal representation. And they consider the credit law, so the Act and the Credit Code, the common law, as well as good industry practice. So the Banking Code of Practice is a good one, and as an industry code of conduct as well.
Anneliese, is it correct that interest keeps going? Or
yes.
Even though the process has stayed?
Yes, yes. So that's something that should be looked at as well, because if the debtor can afford to make some repayments while the process is ongoing, then that can only help in the long term.
Can I ask another question, Anneliese? In terms of the internal dispute resolution process, when you call the bank and say, I'm having trouble paying my loan, are you automatically into that process, or do you have to have that conversation, get a response from the bank, and then say, I want this dealt by your internal, through your internal dispute resolution
it depends
process?
on the bank. Generally, the banks will have a complaints area and an internal dispute resolution area where there's people dedicated to resolving the complaints. If the person is not getting through to their bank manager, then certainly they can request to deal with the complaints resolution area.
But will it be clear to them that they've actually gone through the internal dispute resolution process?
Well, I think it doesn't matter. If they have a go and they don't get anywhere, then go straight to EDR.
Okay.
There's no point in delay if the IDR process is held up internally in the bank. My view is that they get one shot at it, and then the client's entitled to go to EDR. So, looking into a bit more detail at what FOS and COS will do, they will consider whether a code-regulated loan should be varied to assist in circumstances of financial difficulty. They can vary it in cases of hardship. And that's even if the lender did give genuine consideration to the hardship request. But as I said before, the important point is that the debtor can demonstrate that they can get back on track with the loan. If they can't do that, then it might be that selling the house is the only way to go. As I said before as well, once a dispute's lodged with FOS or COSL, all enforcement action, including legal proceedings, is stopped whilst the complaint's before the Ombudsman scheme. In cases of maladministration and irresponsible lending, unconscionable or unjust loans, they can resolve the dispute by deciding that the lender and borrower undertake a course of action to determine what sum of money should be paid. They can forgive or vary certain debts, reduce the debt down, they can release security. They can order that compensation be paid in certain circumstances for financial loss or damage. There is a cap, though, on the amount of compensation that can be ordered. Okay. Before we move on, it's worth making the point with the EDR schemes that they are really quite an accessible avenue for consumers to take, even if they're not legally represented. The caseworkers in FOS and COSL can help the client through the process. Generally, there's a conciliation conference involved, and the parties are given lots of opportunity to try and resolve the dispute before the Ombudsman will look at making a recommendation or a determination after that. Moving on to the repossession process, once a loan payment is overdue, the lender will usually issue a default notice. For code-regulated contracts, there's Section 88 of the code sets out the requirements that the default notice has to include. That will give 30 days to remedy the default. And if in those 30 days the lender pays the arrears plus any enforcement costs, then that will put an end to that issue of default, say that particular issue of default, and it means that the loan won't be accelerated in those circumstances. If the default notice goes ignored, and commonly a notice of exercise of power of sale, which is another notice that the bank has to give under the Property Law Act, and a demand for possession of the property will be included in the same default notice. So if it goes ignored and the default's not remedied in that time period, then the lender will look and say, well, is there someone living in the property? If it's vacant or if it's vacant land, then they don't need to do anything else. They can go and change the locks. If it's vacant land, they can put up a sign. If there's a fence around it, they can lock the fence up, and that's enough. Generally though, there's someone living in the property, so at that point they will institute a court claim for recovery of the money owing, or recovery of possession of the property, or both. Once a court claim is served on the debtor, they will have a period of 28 days to enter a defence. At that point they could also take the matter to an EDR scheme, which will stop the court proceedings whilst the complaint's on foot. But if they do nothing, then at the end of the 28 days, the bank can get a default judgment. They'll serve the judgment generally on the debtor and then proceed to get an enforcement warrant. Now, if there's tenants in the property, so the person living there is not the mortgagor, then the bank will probably have to get leave of the court to enforce the judgment against those tenants and evict them. But either way, an enforcement warrant will be forthcoming, and then the person will be evicted if nothing else is done. That's generally the process. Now, at various steps of this process, there's different options open to the debtor which might stop the eviction happening. So generally speaking, the closer it is to the start, the more options there are available. The closer it is to the end, sometimes there might be nothing more that can be done. So really the take-home message is the earlier the client looks at these issues, or you're seeing a client who has these issues, refer it to us, look for information, think about lodging a dispute with the EDR scheme, and generally there will be more options available. Mortgagee sales, generally this is pretty much standard, I think. They sell it at auction. They need to sell it for market value, so they have to adequately advertise it, obtain a valuation, keep it in good repair, and then sell it at auction for the most part. Sale proceeds go towards the costs of the sale, then the money due under the mortgage and loan, any subsequent mortgages or encumbrances on the property, and it's only then, if there's a surplus, that the mortgagor gets paid the additional amount. If there's a shortfall, so the amount the property is sold for is not enough to cover the amount due and owing under the loan, then the borrower will still be liable to pay the shortfall. So at that point, the bank, if they haven't already got a judgment for money owing, might go and do so. They can then proceed to bankrupt the debtor. They could enforce that judgment against any other eligible property if there is, garnish wages, and that type of thing.
Anneliese, I often hear from clients that I had mortgage insurance. Why doesn't that save me from the shortfall?
That's there to protect the bank, not to protect the debtor. So it is a common problem, and it's a real misunderstanding, I think, that's out there. That mortgage insurance only protects the bank. It doesn't protect the debtor at all. They're still liable for the shortfall. So when to get legal advice? Really can't stress enough that the earlier advice is sought, the more options there might be available. So when the client's in hardship, they might lose their job and might not even be in default yet, but are worried about meeting their loan obligations, refer them to us. We're happy to talk to them. Of course, whenever any court documents received, that could be a situation where urgent advice is required. When a default notice is received, likewise. In some situations, they say, well, I don't owe that money, and that's another thing that we should really be looking at. Or when in doubt. So the earlier they seek help, the more options there are available to them. So this is just our details, our CPU unit. I think there are some details and sheets handed out to you. So feel free to give us a call at any time. We're happy to help you, and more than happy to accept referrals from clients to be booked into our advice clinics. It's important for us in these situations to get the documents before the advice appointment so that we can give the best advice possible to the client. So all the documents will be the loan agreements, mortgage, statement, the account balances, default notices, any correspondence they've received from the bank, court documents, of course. So it's really, I think, the take-home message here will be that if you're in doubt, give us a call. We're really happy to talk to you directly if you have any issues or problems you think a client might be facing. More than happy, of course, to accept a referral to have a client booked into any of our clinics. And as I said, sometimes the earlier we get to them, the better the outcome is in the end. So thanks for listening. I think that's right on time.